Good afternoon, and thank you for taking the time to attend and participate in the second of 3 webinars on the National Criminal Background Check requirements. This webinar is being recorded, so as long as you registered, then you should receive an email notification a couple days from now with the link to the webinar recording. Also, there will be a master slide presentation that will be shared after the webinar series that will contain much of the same information. Today on the call, the presenters are Mary Sprague, a Child Care Program Specialist from Office of Child Care.
Hi everyone, I'm really glad that you all joined us for the second webinar in our series. The first one we had a lot of really good engagement and questions, and so we're looking forward to that again on this webinar.
And Brad Kramer, Senior Business Analyst.
Hi everyone, I'll be covering a majority of the slides today.
And me, Teresa Campisi, a TA Specialist with the Subsidy Center. Before we officially get started today, I'd like to go over a few housekeeping items. With over 200 people attending this webinar, everyone will be on mute, so please type any questions or comments you have in the questions box, and we'll either address them on today's webinar or we'll try to provide responses after the webinar. You may also utilize the hand-raising feature, and one of our organizers will unmute you. We will also have a few polls throughout the webinar, so don't forget to vote. And as a reminder, this webinar series is a series of different webinars. We hope to answer different questions or review different clarifications. And the new clarifications we review partly depend on your responses to the polls and evaluation questions, which will be asked at the end of the webinar. And just one more reminder to utilize the questions box for questions or comments. This is just a quick reminder that during the first webinar, we introduced the draft of the Child Care Subsidy Criminal Background Check Contact List. This list was created to ease the burden of finding other states' contact information, but we need your help to keep the contact list updated and ensure accuracy. An email was sent on Friday to state administrators and co-state administrators. If you didn't receive the email, please feel free to contact me and I'll send it out to you. We've already received 2 responses. So each lead agency should assign a point person for the contact list. The point person will then contact me, Teresa Campisi, by November 13th, 2017, with confirmation of accuracy or edits. We will create a distribution list for periodic reminders on updating the criminal background check contact list. And based on feedback from the first webinar, updates will be sent to me as changes occur to the information. Once we receive updates, the contact list will be located on the Early Childhood Training and Technical Assistance website. And we'll continue to remind you, send your updates, since this contact list is only as successful as the people who are sending me the updates. We're now going to move on to the next agenda item, applicability of background check requirements.
Thank you, Teresa. Hi, everybody. This is Brad Kramer. I'm going to pick up the slides from here for a while. And we're going to first talk about the applicability of the background check requirements, and then which individuals are subject to those checks. At that point, we will take our first pause for questions. So if you have questions develop as I'm covering these, please utilize the chat box or feel free to raise your hand if you'd like to ask your question in person. I do encourage you to use the chat box if at all possible, because we do have over 200 people on, and it might be the easiest to use the chat box. Actually, you should have on your dashboard a question box where you can enter those. Okay, so talking about the applicability of the background check requirements, what this refers to is really which provider types are required to adhere to the background check guidelines with respect to current and prospective employees. And so this table tries to summarize that in 2 columns. There are providers who must comply on the left, and then providers who do not have to comply on the right. So starting with who must comply, all licensed, regulated, or registered providers, with the exception of relative providers, and any provider who receives CCDF funds except for relative providers. Those who do not have to comply are license exempt providers who do not receive CCDF funds, and relative providers never have to adhere whether or not they get CCDF funds. And I just wanted to point out the footnote there that states do have the flexibility to determine which providers are considered licensed, regulated, or registered. Those do vary from state to state, so I just wanted to point that out. So now that we've identified which provider types have to adhere to the regulations, the requirements, now we're going to look at those individuals within those particular providers to see who is subject to the background checks. So the table breaks it down pretty easily, I think. And we're going to start with any individual who is employed by a provider for compensation. And again, this is any of the providers that fall within the categories we just spoke about. If they're employed for compensation, they're subject to the check. It doesn't matter if they are providing care or if they are a cook in the kitchen. If they are employed by that provider and they get a paycheck, they are subject to those checks. Any individual who is either a contracted employee or self-employed also must get the background checks. Any individual who cares for, supervises, or has unsupervised access to children in the child care setting. And then lastly, any individual who is an adult living within a family home provider. So if you are a provider type that meets the background check requirement, applicability rules, and you're an individual that meets any one of those 4 categories, you must have the background checks completed as indicated. So I'm going to pause there for questions. I know that we did have some questions about this last week, and that's why we wanted to cover it in a little bit more detail this week and give the opportunity for additional questions.
Okay, so last week we got some really good questions around applicability, which is, like Brad said, the reason why we wanted to cover it again. One of the questions that came up last week that I just wanted to clarify is around in-home care. So that's care in a child's home when a provider is coming in to care for the child. So the question was, for in-home care, are we required to have background checks for everyone in that home age 18 and older? And the answer to that is no. So for in-home care, it's only the caregiver that would be required to have background checks. For family child care homes, which are child care businesses operated out of someone's home, in that case, any individual age 18 or older would be required to have a background check if they're residing in that home. Okay, let's see. There's a bunch of questions coming in, so I'm going to Okay, so here's one that came up last week, but I think is probably good to address again. So do volunteers need to have background checks? So what we've said is that the CCDBG Act and the final rule, neither of them address volunteers. So that's an area of state flexibility. So that's a place where you can make a decision about what background checks volunteers need to have to care for children. So there's a couple questions here about how this requirement applies to employees that are not caring for children, particularly in child care centers. So the answer to that is the law defined a child care staff member as somebody who is employed by a child care provider or whose activities involve the care or supervision to children or unsupervised access to children. So the definition is really broad of who it covers. So even individuals that are not directly caring for children need to have a background check if they're employed by the child care provider. Okay, so here's another question about a follow-up to care in the child's home. So when there's an in-home child care situation, which is when the caregiver is coming to the child's home to provide care, only that caregiver would need a background check. Hopefully that clarifies that. So here's a question about, can you give an example of a contracted employee? So we added the terms contract employee or self-employed individuals to the definition of child care staff member. And we added those in because the definition is really written with center-based child care providers in mind. And so we wanted to add some language that would speak more to family child care providers, which is why we added both of those in. Okay, so there are a bunch of questions coming in, but I think it might be good for us to move on. And then we'll have some time for questions at the end. I just want to make sure that we can get through everything that we want to today. So actually, I am going to keep talking to you all. So we're changing over to the differences between some of these required components of a background check. And so this first one actually has come up often in our conversations with states, and it's what is the difference between doing a search of the National Crime Information Center, National Sex Offender Registry, and doing a search of the National Sex Offender Public Website. So the National Sex Offender Public Website is a pointer system. So it's pointing to all of the state's public websites of their sex offender registries. But the National Crime Information Center National Sex Offender Registry, which we refer to as NSOR, is something different. So that's actually a file that's maintained by the FBI, and that has information that states have submitted to the FBI to that registry. So the requirement from the law, and that we clarified in the rule, is to perform a separate name-based search of the NSOR. So I know that you all have been talking to your state criminal justice folks, and oftentimes what we hear back from them is that we're already searching the NSOR, so we don't need to do a separate name-based search. So the reality is, when you are doing an FBI fingerprint check, you are also performing a check of the NSOR, but you're only checking those cases that have fingerprints attached. And there are a small number of cases where there's only name-based information, and that's due to a number of different reasons. Sometimes fingerprints were rejected, or they weren't, people weren't fingerprinted at the time of their arrest. So those small number of cases can only be accessed through a name-based search, which is why we're requiring a separate name-based search of the NSOR. We also recently, just last week, sent out an announcement about a program instruction that we released on the NSOR. And so I think Teresa is going to bring that up. Okay, so this program instruction is speaking to some guidance that the FBI actually released on our behalf earlier this summer. So the FBI sent out a letter to all of their contacts at the state criminal repositories, and basically the letter is outlining all of the CCDF background check requirements and clarifying to them that our law, the CCDBG Act, requires a separate name-based search of the NSOR, and they are allowed to perform this search and give the results to the CCDF lead agencies. So in response to that letter, we've released this PI to let you all know. The FBI has released guidance, and now we're releasing guidance to let you all know that you can start performing this search. So I'm going to pause and see if there are any questions about this. So how is the FBI responding to states that cannot run a check of the NSOR? Oh, sorry, it's jumping around. So how is the FBI responding to states that cannot run a check of the NSOR without including other NCIC data on the response? So this is probably a question that's best addressed by the FBI. In their letter, what they do is they clarify technically how a state can do this search, which message code they can use to do the search. So I think it's probably best to follow up with them for a more comprehensive response. So here's a question, are child care center directors able to access the information for the NSOR? So the answer to that is no. So, and there's a number of different reasons for that, but the way that the CCDBG Act lays out the background check requirements, states are required to perform these searches and then determine whether the individual is eligible or ineligible. And so once they've made that determination, they send center directors or child care providers, they send basically a red light, green light response. So yes, that individual is eligible, or no, the individual is not eligible. And then they also follow up separately with the individual if they're ineligible and let them know each disqualifying crime and give them an opportunity to appeal. So the center directors will not have access to any of the disqualifying information. Oh, so here's a good question. Has any consideration been given for additional extension to the NCIC NSOR requirements? So I'm glad you asked that, because in the program instruction, we do address that. So states are given until September 30th of 2018 to implement the NSOR check. So here's another question. When you say National Sex Offender Registry check, are you referring to the web-based registry, the National Sex Offender Public website that states can check for themselves? So no, when we're talking about the NSOR or the National Sex Offender Registry, we're talking about a file that's maintained by the FBI. Law enforcement have access, but it is not a public file. So the National Sex Offender Public website points to state public websites, but it is not, checking that website does not satisfy the requirement to check the National Sex Offender Registry. Okay, so there's more questions coming in, but I think I'm going to turn it back over to Brad, and we'll have some more time at the end.
Thank you, Mary. Okay, our next agenda topic is going to talk about criminal history checks, and specifically the difference between an FBI check and the in-state and interstate criminal repository checks. So just to provide a few clarifying points here, the FBI fingerprint check provides access to a national criminal history record information across state lines on people that have been arrested for felonies and some misdemeanors under state, federal, or tribal law. There are instances where there may be information in state databases that does not make it into the FBI database for a variety of reasons. And so therefore, searching both the criminal state records and the FBI fingerprint check is going to be the best way to receive full up-to-date responses. That's going to mitigate any differences between the state and national database. And also the last point here, doing both the checks is a better way to address individuals that aren't necessarily forthcoming regarding their past residences, or they may have committed crimes in a state where they did not reside. Moving on to this next slide, now we're going to talk a little bit about some exceptions where you don't have to do an interstate check. And this revolves around the National Fingerprint File, or NFF states. If you are an NFF state, the FBI has direct access into your state criminal repository. And so therefore, an FBI check and an interstate check of that particular state would reveal the exact same results. If you happen to be the requesting state and you're an NFF state, I do want to point out that doing your own in-state check prior to submitting to the FBI is a prerequisite from the FBI. Even though they have access to your database and would be checking it as part of their national check, in order to limit the volume of requests coming in, they want NFF states, as the requesting state, to run their own in-state check first. And then if there are disqualifying crimes listed, there's no need to proceed with an FBI check because the individual would have already been disqualified. We'll talk about that a little bit more, but let me direct your attention now to the actual points on the slide, and then I'm going to give you some real-life examples. So speaking specifically about the requesting state, and that's typically the state of residence of the prospective employee. Participating in the NFF program does not prevent the need for your own in-state criminal history check. And as I mentioned, the FBI requires the requesting state to conduct their own prior to submitting the FBI check. Now, when we're speaking about responding states or those out-of-state checks, the FBI check alone satisfies the need for the interstate check as well as the national FBI check. And the reason for that, again, like I said a few minutes ago, is when the FBI conducts their national check, they will look directly at those states' individual state criminal history databases as part of their check. So that brings us to a slide with a table on that hopes to summarize this a little better. On the left-hand column, we see the various components of background checks. And then we have a column for which states that happen to be participating in NFF must complete, as well as the last column, states not participating in NFF must complete. And I just want to point out here that this slide, this table has been updated recently with some newly learned clarification from the FBI. And that clarification specifically is about that prerequisite in-state check that I mentioned a few moments ago. So, every instance requires an FBI check and a National Criminal Information Sex Offender Registry check and an in-state criminal repository check using the fingerprints. That's whether you're NFF or not. If you are NFF, that in-state criminal repository check must be conducted prior to completing the FBI request. If you conduct your in-state search and you get a disqualifying crime, you can pretty much stop there, and then you don't have to proceed with any of the other checks. Where we see the next line down, interstate criminal repository in other states of residence for the past 5 years, if those other states, those intra or out-of-state requests are states that participate in NFF, you do not need to send a criminal history check out to those states. The FBI check will look at those records in addition to their national search. So those are only required for states that are non-NFF. There are no exceptions to the sex offender registry or the child abuse and neglect registries. Those are always still required. So who are the NFF states? This map gives us a breakdown of which states are participating in the National Fingerprint File. The states you see in purple are the ones where they are participating, and the FBI has direct access to each one of their individual state databases for the check. So again, if you are the requesting state, whether you are NFF or not, you've got to conduct your own in-state check. If you're doing it because you're NFF, it's a prerequisite for the FBI to then accept your request. And if you're not NFF, it's the only way to search directly into your database. I'm going to give you a few examples in hopes of heading off some of the questions that may be coming in, but still feel free to enter your questions in the question box, and we'll pause after the examples for further clarifications. So bear with me here. I have several different scenarios that we've been asked about, and hopefully this will help clarify when the state requests are required and when they're not. So in this first example, it's pretty cut and dry and straightforward. Let's assume that the individual lives in Florida, which happens to be an NFF state, and they've never resided anywhere else. For the state of Florida, the in-state criminal history check is required, even though it's an NFF state, again, because the FBI requires that as a prerequisite to submitting a national check. Moving on to example number 2. If the individual lives in Florida and also lived in Georgia within the past 5 years, both states are NFF, the Florida in-state check must be done as the prerequisite. The national FBI fingerprint check must be conducted. The Georgia interstate criminal history check is not required. The reason it's not required is because the FBI will look directly into their database and cover that request for you. In our next example, the individual lives in Alabama, which is a non-NFF state, but has never resided anywhere else. The national FBI fingerprint check is required, and the Alabama in-state check is required because they are NFF. I apologize, they're not NFF, but even if they were, it still would have been required as a prerequisite. The last 2 examples before we pause for questions. Individual lives in Florida, also lived in Georgia and Alabama within the previous 5 years. The Florida in-state check must be required as a prerequisite. The national FBI fingerprint criminal history check is required. Georgia is not required because it's an NFF state. Alabama is required because it is not an NFF state. The only way to get a state-level check on a non-NFF state is to do that check directly. The last example, the individual lives in California, also lived in Oregon, Washington, and Idaho within the past 5 years. So we need the national check. The California check is required. The Oregon check is not required. Washington is required. Idaho is not required. So before I move on to the question slide, I just want to try to summarize this in one statement that hopefully will clarify some things. Regardless of NFF status, the requesting state must always complete an in-state check. When you are considering the previous states of residence, the out-of-state direct state check is only required when the states do not participate in NFF. The NFF does not allow any exceptions for National Sex Offender Registry or child abuse and neglect. These are only for criminal history background checks. And now I'm going to open it up for questions, and Mary is going to address those as they come in.
Yep. So while Brad was talking, we got some really good questions about the NFF. So there's some related to, do we think that other states will join those 20 states that are part of the NFF, and how do we get more states to join the NFF? So we didn't put this up on the slides because it's kind of getting a little bit into the weeds, but since it came in as a question, I just figured I would kind of talk this through with you all. So the process for joining the NFF, from our understanding, is a two-step process. So the first step would be for the state to join the FBI Compact Council, and so that involves passing legislation to ratify the FBI Compact. And so far, there are 31 states that have done that. Of those 31 states, 20 have taken the next step, which is to make changes in the state's IT systems to better interface with the FBI. So that's the second step. So the first step is passing legislation, and the second step is a financial investment into your IT systems. We've been talking with the FBI because it seems like having more states be part of the NFF would make these interstate requirements, at least the requirement to do interstate checks of the criminal repository, would make that easier. And they have told us that there are states working on joining. Let's see, we also have some more questions around applicability that came in that I wanted a chance to go over. So here's a question. If a child care employee is under age 18, do they still need a background check? So the answer to that is yes. If they're under age 18, but they are employed by the child care provider, or their activities involve the care or supervision of children, then, or unsupervised access to children, then yes, they need a background check. We also got a couple questions about construction workers or plumbers that may come in to do some work for the child care provider. So do those individuals need a background check? So the answer to that is no. So that's an area of state flexibility, and the federal requirements do not apply to like the plumber who's coming in to do just some short-term work. So what about other people that are coming in to the child care provider? So there's a question about speech therapists or other individuals that are coming in to work with kids. So we actually have this question up on our website as part of our frequently asked questions. But the short answer is the law defines a child care staff member to be somebody who's employed by the child care provider or whose activities involve the care or supervision of children or unsupervised access to children. States have the flexibility to decide whether or not those individuals, like speech therapists, fall under that definition or not. So there's some state flexibility there. Okay, so here's another one about, there's a bunch of questions around applicability. So for a family child care provider, how soon after an individual turns 18 do they need a background check? So this is also an area of state flexibility. Neither the law nor the rule addresses the exact time that that individual needs a background check. So there's some flexibility in the timing there. Okay. Let's see. So we have a question about the turnaround time for these checks. So the question is how long typically do these checks take to come back? So this really varies state by state, but we've spoken with the FBI about this, and when an FBI fingerprint check goes through, their turnaround time is typically less than 24 hours. So it can be pretty quick. Okay. So I'm just scrolling through to see some of the other questions that have come in. So there's a couple questions about individuals that reside in one state and work in another. So the example is somebody in Massachusetts living in Rhode Island. So the way the law and the rules speak about this is the state where the individual resides, so where they live. So you're required to do in-state checks of the state where the individual resides. Okay, so here's a question about the 45-day time frame. So the law requires the background checks to be completed within 45 days. And we've given states flexibility to decide what to do at the end of that 45 days. So we're expecting that once states get all of their systems running, that these checks will be able to happen pretty quickly. But particularly in the case of interstate checks, at the end of the 45 days, states can decide what steps come next. And we're not expecting that we'll penalize any states that have requested background check information from another state and haven't received a response. Okay. All right, so here's a question that just came in. Can a person start working before all of the background check information is completed? So we talked a little bit about this on our last webinar, but there are requirements related to provisional employment. So the final rule requires an individual to pass either the FBI fingerprint check or their in-state criminal repository check using fingerprints before they can start working. And once they're working, they have to be supervised by someone who has passed an entire background check until all of the components are completed. And when I say they've passed, the state has to have done the search and then reviewed the results and determined that they're eligible to work. So this is actually a really hot topic, and we get questions about this all the time. So we're planning a whole nother webinar probably in December that will address this issue and kind of go more in depth on what the requirements are and kind of do some brainstorming about what we can do to help people get to work. So here's a question. Why is it required to run background checks on employees under the age of 18? So the law requires anybody who's employed by a child care provider or who's caring for children to have a background check. And as we all know, background checks are important for ensuring the health and safety of children. And so employees that are under age 18 are not exempted from the background check requirements. Okay, I'm just scrolling through to see if we have any other questions. So I think we'll just keep going, and then if we have any last minute questions, we'll address those.
Okay, thanks, Mary. So what you should see now is a slide of resources. This should look pretty familiar to you, as we also shared it last week. The only additional one is that last bullet, the PI for implementing the National Crime Information Center National Sex Offender Registry background check requirement. And now we're going to move on to a couple of polls. So the first one is, what topic would you like to discuss on the next webinar? Again, this should look pretty familiar, as this is a question that we asked last week. Okay, I'm going to close the poll and show the results. So it looks like disqualifying results came in the lead with 61%. Then Head Start versus CCDF requirements at 46%. Prospective staff members at 41%. 18% on more clarification on today's clarification. So the next poll we have, do you have a best practice you'd like to share with the group? Okay, I'm going to close that, share the results. We have 75% at no, 24% at let me think it over, and we have 1% at yes. And the final polling question, do you have a best practice you'd like to share specifically around provisional employment? If you do have something specifically around provisional employment, you can type something in whenever you type in the question box. You can also email me directly, which my email address has been given out several times, or whenever you get the evaluation at the end of this webinar, you can also type in a response at that point. Some ideas you may want to consider. How has your state overcome the requirement for not hiring someone until after they receive either their FBI fingerprint or their in-state fingerprint check? Has your state had to work with an FBI-approved channeler for fingerprints to increase the number of fingerprint sites throughout your state? Or what policies has your state had to change to become compliant with this requirement? So we have 66% at no. We have 33% no, but someone please share because we need your help. There's 7% at let me think it over, and 4% at yes. So at this time, we would like to thank you for attending our webinar, and I believe Mary will address a couple more questions while we wait for the webinar to be over.
Okay, so we only have a few more questions. So here's one. If a person has successfully completed a background check for another provider within the past 5 years, can that person begin work for a new employer immediately, or do they have to have another background check? So that's a really good question, and actually this is addressed by the law. So if somebody has had a background check within the past 5 years and they haven't been separated for work for more than 180 consecutive days, then they do not need another background check, and they can begin work for another child care provider. Let's see. So I think there's still a number of questions that we haven't gotten to, but hopefully we'll be able to address those in future webinars. So we still have another one in this series that's happening next week. So hopefully we can continue these conversations with you all then.
Okay, well, thank you again for participating in the webinar and attending. We do hope that you were able to have some of your questions answered, and we definitely look forward to hearing about any other questions that you may have at this time. Thank you.